In dieser sich ändernden Welt, wie garantieren wir unsere Sicherheit? Wie schaffen wir es als Europäer, dafür zu sorgen, dass wir sicher leben können?
Ce qui manque le plus à l'Europe aujourd'hui, à cette Europe de la défense, c'est une culture stratégique commune.
The rise of China matters for all NATO allies.
The Defense Cafe, a podcast by the Friedrich Naumann Foundation.
Hello and welcome to the Defense Cafe, the liberal security and defense podcast from the Friedrich Naumann Foundation in Brussels. My name is Jeroen Dobber from the Friedrich Naumann Foundation.
And I am Teresa Reiter in Vienna.
And today we will be speaking with Isabella Brunner about the topic of international law and cyber conflict. Isabella is a leading expert in Austria on this topic. She currently works at the University of Vienna as a researcher. And earlier this year, we had Isabella as a guest speaker during one of our meetings with the liberal defense experts. And she brought up some really interesting points there about the applicability of international law to cyberspace and also the public discussion about that. And at the time, we didn't have time to discuss all of that, so we decided to invite her back for the podcast to talk about it a bit more. So today with Isabella, we will speak about
the importance of correct terminology and the right word, why cyber war might not be the right word, on what we should say instead, whether a cyber treaty is the solution, and what actually happens if there is a cyber violation of international law? What options do states have? So all of that we're going to discuss with her today.
Sounds good. Let's get started.
So Isabella was nice enough to join one of our meetings. As many of our listeners know, that this podcast is part of the Friedrich Naumann Foundation Security Hub, which consists of national policy advisors in the field of defense and foreign policy and security. And we learned a lot about the whole cybersphere and international law from Isabella. And there was one point that was especially crucial and that she kept repeating, which was the correct terminology. So the thing that we face as policy advisors when we frame a certain topic to our audience, to our target groups, is that we have to catch their interest and make it more interesting. And cybersecurity in itself doesn't sound too, exciting sometimes. So after a while, policy advisors started using cyber war, information warfare, stuff like that. Can you explain to us what that problem is, in your opinion?
So when we talk about cyber war in the international law sense, we think about armed conflict. Similarly to cyber war, I also have an issue with cyber attacks because in the international law sense, we think about armed attacks, which are definitely much more of an escalation than the mere cyber operation that you know, such as an espionage operation that is being conducted on a frequent level. So cyber war in that sense would either mean that you have an armed conflict, so either a conflict between two states, armed hostilities, or between a state and an urgent group. And when it comes to cyber, the component of cyber, that would mean, for example, if you have a kinetic conflict, so a conflict that already uses kinetic weapons such as military tanks or rockets or whatever, and then you also have a cyber component such as, for example, a malware that is being infiltrated in the system of the opponent's state, and that causes that system to become incapacitated. And the other scenario would be that you would have an actual armed conflict that is only being executed in the cyberspace. But that would mean that this would have to reach a very high threshold of force. So it would have to have armed force between two states that can actually be conducted through cyberspace, which means that the effects of that separation would have to reach the same as it would in the kinetic world. So it would have physical destruction, injury, or death. And that is something that fortunately has not yet occurred, or at least that is the common consensus, that we have not yet had such a cyber war that is only being conducted in cyberspace alone.
Which is interesting because a lot of experts, especially I remember talking to experts from the German and the Austrian Ministry of Defense, and many of them are in the opinion that we are in a constant cyber war in this world right now.
So yeah, I think that's an interesting point, Teresa, and I think that's exactly what is happening in other countries as well, such as by US members of Congress who termed the SolarWinds espionage hack as an act of war, which in fact, as has been noted by commentators, that this is actually just a mere intelligence collection operation and not an actual attack on the infrastructure of the United States. So using the term cyber war, in my opinion at least, escalates the situation even further. And that's why I think it is important to, stay calm and call these things in a different way, such as, for example, we can use the term cyber operation, which is more neutral, is of course not that sexy, but explains what it is.
Yeah, we could say hostile cyber operation or something. So it's clear it's not just something normal that just occurs, right?
Yeah.
One more question related to that. Do you see states being reluctant calling something an armed attack in this field, while at the same time using escalating wording for things like that it just described? But from what I can see, states also hesitate saying we were attacked by, so the question of attribution. Is that because of fear of escalation as well? And do you see this more than maybe the other thing that you just described?
Yeah, I think you can definitely see a tendency of states being reluctant to use terminology of international law when they refer to a cyber option. I think that is because some states are afraid if they call it a violation of international law, then the opposite side could also call this anything else that the other state has done a violation of international law. To give an example, with the SolarWinds espionage operation, I think it is, or there are at least some commentators who note that this operation against the United States was an espionage operation, and we could say under international law that such severe espionage operations would be a violation of the rule of sovereignty. But then if the United States was saying that this was a violation of the rule of sovereignty, then Russia could also say, well, I mean, all these espionage operations that the United States is conducting against Russia, these could also be then a violation of the rule of sovereignty. So I think states are a bit afraid of using that terminology because that could have consequences for them as well. And at the moment, I think states are currently trying to figure out these rules and how they can apply them, which is a definitely good thing. But also at the same time, up until now, we could see that states tend to be a bit reluctant to use international law terminology.
I think that's quite interesting because that also means that states are actually very well aware of the applicability of international law to the cyber realm, right?
Yes, but I mean, in that context, I think we can also talk a little bit about the debate that is currently going on the international plane, especially at the United Nations, where we struggled actually up until now with whether international law fully applies in cyberspace. So there had been some states such as, for example, Russia, Cuba, China, etc., who at the beginning of the negotiations at UN level were a bit reluctant to say that international law fully applies in cyberspace, whereas other states like the United States, United Kingdom, and the European Union as well was very much saying, well, international law fully applies. But I think the other major question is how it applies. So, for example, again, with the example of sovereignty, there is a lot of debate even among Western scholars whether the sovereignty is actually a binding rule or just merely an overarching principle. For example, the United Kingdom denies that sovereignty is a binding rule, especially because of, other implications that we've just discussed. But Austria has actually confirmed at the United Nations that we believe in a binding rule of sovereignty.
You mentioned China, Russia, Cuba having second thoughts about this, didn't want this to become international law or call it that. Why is that? What were their arguments?
I would say the arguments were very much political in nature. At the United Nations, there's a lot of talk, but substance is sometimes missing, I would say, especially when it comes to that, because I think China was a bit concerned about the applicability of international humanitarian law, saying that if we accept the applicability of international humanitarian law, which regulates the conduct of troops or regulates armed conflicts, then we also admit that conflicts can take place in cyberspace. So with denying the applicability, we kind of deny the fact that conflicts can take place in cyberspace, which of course is a political argument and not really a logical one, because we also have a prohibition to use force, but states do not actually break that rule and do conduct armed conflicts with each other. So it is important to have rules that regulate how these conflicts are then being regulated, or what can be attacked and what cannot be attacked. And by denying this unfortunately leads to basically a gap in international law. So that is one argument. Apart from that, Russia and China, etc., have been pushing for a new legally binding instrument which would regulate the conduct in cyberspace, but they have not been very clear about where the gaps are in current international law that needs regulation. I think it's more of a political argument than a legal one.
Yeah, I think that's interesting that you bring that up, because I think it's not only there, but also in a number of European countries that this idea is brought up, that we need some kind of cyber warfare convention or a new legal framework to deal with cyber conflict. And what you say, that it's not clear where exactly those gaps are. I think that that's also a question that is relevant to a lot of European countries where this discussion is taking place. Do you see any of those gaps in current international law that have to be filled or that can be addressed through such a convention?
Can I just add to this, just to catch our listeners up to what we already learned in our meeting? We thought when someone asked us, are you in favor of a cyber treaty? The first answer of anyone who is in favor of multilateralism and international cooperation is yes. But then you explain to us how this might actually confuse things. Maybe you can also do this for our listeners now, because that was a crucial point for us as well. Because the politicians answer, yeah, of course, we need a cyber treaty, we need cooperation, right? So is that the only way to achieve that, or is there maybe another option?
I would say that international law itself is already sufficient, especially with its overarching prohibition to use force. And I think that is definitely a very powerful prohibition that should be adhered to by states. I think next to that, obviously, there are certain systems or infrastructures that could definitely benefit from a better protection than they have already benefited from. So, for example, making it clear that critical infrastructure should be off limits to attacks. Something where all states could agree on this, I think that would be definitely something where a convention wouldn't be that harmful. In that context, maybe it is important to say that, however, that already existing agreements or existing mechanisms that are taking place, such as the group of governmental experts at UN level and the open-ended working group that had existed at UN level until March 2021, where states have come together to discuss these issues and have agreed that critical infrastructure merits further protection. And the latest group of governmental experts that has finished its report in March 2021, also a UN body, has also noted that critical infrastructure merits more protection and also has developed certain voluntary non-binding norms which states should all adhere to. So you could argue there are already existing frameworks that seek such as critical infrastructure. And therefore, the question is whether a new treaty would actually make it better, or if we should focus on this already existing framework. And maybe to answer also Teresa's question, why not a treaty? I think the overarching argument is that if you create a new convention that regulates cyber operations, I think there are a couple of states that see the danger of other states using this as a pretext to further their surveillance on their own citizens, because compared to biological weapons conventions or chemical weapons conventions or the prohibition of nuclear weapons, these are weapons that are being created by a handful of institutions or states, etc. And obviously, it is clear that these should be prohibited. But with respect to cyber operations, these are being conducted on a laptop, on something that you and I use on every single day. It is extremely difficult to prohibit action on a computer than it is to, for example, prohibit the use of chemical weapons.
As you said, everything that you described on the UN level, this is voluntary, right? It's not legally binding. So how effective is a framework that is not legally binding? And if I might add, nobody has even really heard of it. I know states are aware that this exists, but when I looked it up after your talk at our meeting, I had to look for a long time until I found the actual wording of what was agreed in this meeting. So if this is like a code of conduct for states, wouldn't it make a lot of sense to also talk about this a lot so citizens know and can keep their own governments in check?
So these are voluntary non-binding norms and not international law. This is where it gets even more confusing, because obviously the attack on critical infrastructure is already prohibited under international law. So if you attack critical infrastructure that has the effect of having a severe damage on the civilian population, I think every international lawyer will say, well, it's prohibited under international law. but the commitment to protect critical infrastructure and to use all means at a state's disposal to make sure that this infrastructure is being protected, that is an only political commitment. And there is definitely a question whether you could turn that into a binding obligation. I think the concern here again is that a lot of states have different capacities. And if you make this a binding obligation, this could mean that those states that do not have the capacities at the moment have a much more bigger pressure on themselves to make sure that they align with international law. So I think that is one of the reasons why this has not been turned into a binding obligation.
And this might mean that they will not agree it in the first place, right? That's the worry then.
Yeah, that is correct. The same is true with, for example, an obligation that exists in traditional international law that states should make sure that nothing on the territory is being used to conduct an internationally wrongful act against another state. So, for example, if a state harbors non-state actors that conduct a cyber operation, that the state should make sure that these non-state actors cannot be harmful to another state. Translated to the cyber context. This is also something I think where a lot of states are struggling with, because that would impose also a huge obligation on the states to make sure that private actors do not do anything harmful to another state, which could also potentially be used by other states as a pretext to, tighten surveillance in their own country. So that is one reason. And as to why this is not really in the public domain or why this is not being discussed, I think that's a very difficult question. I think, especially in Austria, there's not much going on at the moment where we do not have as many people interested in this subject where we could have built a platform to inform citizens. But I think this would definitely be great to actually jumpstart something to start to talk also to national politicians about this subject.
Yeah, we'll talk about that over coffee.
Maybe to give you an example, I had the honor to present the Austrian statement on international law at the United Nations. And a colleague of mine, actually, an international lawyer, he posted my statement, I think, a couple of months later, and was really shocked that he hadn't heard about that, because it was not really publicly available or anywhere. It was just on UN Web TV. And then I told him, that I did that statement, and I think he was really shocked that Austria was saying something really important, but nobody actually knew about it in Austria itself.
I think Austria is not the only country that has this problem. I mean, we haven't said that in the podcast yet, but we realized, starting with this whole project and discussion on the cyber sphere in security policy, that there are not that many people who publicly speak about it anyway, of no aspect. We need to invest more in cyber defense and threats of the future, blah, blah, blah. You have heard this. While it is not actually a threat of the future anymore, but already has been around for a while now. Beyond that, there are not that many people, not that many experts, not that many politicians or parts of armies that would openly say something definite on these issues. And if it doesn't come from them, who is in charge of talking about this, right? So it's definitely a public debate that hasn't happened yet, which is something we will get back to later.
Kind of going back to the definition question that we had before, that was a thing that I was wondering when you were explaining that. We shouldn't talk about cyber war so much anymore, because that's actually quite an extreme scenario. Then we can talk about cyber operations. That's something that occurs much more often. But if a cyber operation occurs somewhere, and let's take a hypothetical scenario that causes severe damage to critical infrastructure somewhere in a country, what kind of legal mechanisms kick into action there? What is the process that starts then? Could you take us along in that? Because for me, that's still a bit unclear what that looks like.
So the legal consequences from a breach are regulated by the so-called law of state responsibility. And for that, of course, you need first an internationally wrongful act. And you need to be able to attribute this act to a state. So first of all, we would have to establish that this actually constituted a breach of international law, so that it is an internationally wrongful act, and with a severe damage at a critical infrastructure to the effect that it actually had physical damage. For example, sometimes the Stuxnet incident in 2010, which was an attack against a nuclear facility plant in Iran, where Iran had to exchange actual centrifuges of its facility plant, was sometimes argued to be a violation of the prohibition of use of force, because it actually led to, arguably, to physical destruction, or basically to same effect as the centrifuges had to be exchanged. If you take that scenario and you admit that this is a violation of international law, then you would also have to attribute it to a state in order for international responsibility to arise. And this attribution is extremely difficult in the cyber context to undertake, especially because we have a lot of possibilities of staying anonymous in cyberspace. For example, sometimes as an indicator, you can take the IP address from where the attack was launched, but that IP address can also be spoofed, so faked, and in that way it can also make it more difficult to find out who actually was behind the operation. Then, of course, you have this whole issue of non-state actors who do not act under the control of the state, but who do things themselves, who are patriotic hackers, who, for example, in the incident of Estonia in 2007, it was widely claimed that Russian patriotic hackers were actually in charge of a so-called denial of service attack against Estonia. And here, international law remains quite silent. It says that acts of non-state actors that are being controlled or directed or instructed by a state are definitely attributable, but anything below that threshold is more difficult. So, of course, here you have issues with international law, but also you have issues with respect to the evidential realm. So trying to prove this attribution if you manage to establish that link. And then a state could invoke that responsibility against the other state. It could do that, for example, at the International Court of Justice, if the International Court of Justice has jurisdiction in that specific incident. It could do that also by publicly condemning the act, something that has happened quite frequently recently, where also collectively states have come forward to say that a certain operation was not okay. I mean, they were not using international law terms, as we've just said, but they've definitely attributed the incident to specific actors, such as with the SolarWinds hack, the United States attributes that to Russia, or also other incidents.
And can I just say, this basically just means that they publicly say something was done and we know you did it. And then probably the real life consequences for the country that did it would be somewhere in the diplomatic channels, right? So we wouldn't necessarily see it immediately if a state reacts to that unless the state wants everyone to see it.
Exactly. So in legal terms, international law also provides for certain reparations. So you can ask for compensation, for example, if you suffered economic consequences from that. You can also get guarantees of non-repetition, so that you ask the state to not do it again. You also can ask it to cease the act. So these are all possibilities, but in practice, obviously, at the moment, so far, not much has happened. And obviously, I think the major issue with that is the attribution, because you have to prove the act has occurred and has been undertaken by a state. In most incidences, when Russia, for example, was allegedly the perpetrator, Russia denied these acts and was just basically saying, well, you don't have any proof. And here we have, again, the issuing any evidence publicly, not saying publicly, providing evidence to the public. And so it is quite easy for the state that is the alleged perpetrator to say, well, I mean, you don't have any evidence against us.
Is that a problem, you think, that actually these cases almost never end up in court?
For sure. Relative to international law, cyber operations are quite a new phenomenon. So it's not surprising that there hasn't been an incident that has actually occurred in court in an international tribunal. I mean, we had incidences where, for example, in US courts, for example, with the NotPetya incident, where there's an insurance dispute at the moment going on where with Mondelez, which is trying to get insurance for its damage that was caused by NotPetya. And the insurance company is saying, well, this is not covered by the insurance because this was an act of war. And here we also have international law kind of getting into the court, but hasn't been dealt with in an international court. And I mean, it would be great if we had a ruling of an international court or tribunal that would say that this is a violation of international law, because this would give all of this much more weight and credibility, and for states to use this, to apply this in their own condemnations of a malicious cyber operation.
One more thing to our listeners, the kind of evidence that you can have in this situation. One of the experts talking to us recently said, if you have a good linguist, all of these threat actors have kind of their own fingerprint in terms of how they work. And you can see what kind of keyboard was used, for example, if you're really good at this and all of that. But we heard that the problem is also that individual hackers switch group from time to time to make this fingerprint, this so-called fingerprint, less detectable to the other side. Is that true, or what is your take on that?
That's a really, really good point. And this is something I also address in my PhD, all the aspects of evidence, because what you can do is, as you said, you can check which language is being used on the keyboard, for example. That could be an indication that, for example, if Chinese Mandarin is being used on the keyboard, this is a high indicator that this operation was launched by a Chinese fluent person. But anything beyond that is more difficult to prove. You can also correlate that then with time zone. For example, if the operations occur always in a time frame that's happening in the morning in China, and, for example, the attacks are going on between 7 a.m. and 10 p.m. in China time zone, then this is another correlating indicator that this could have been launched from China. But obviously, you can also just be in the United States and wake up at the time zone of China, be a Chinese-speaking person, and you have the same result. So this is all circumstantial evidence, which is not direct proof, but indirect evidence. And that would definitely have to reach a higher standard of proof in order to be able to actually, have a single logical conclusion to which you can come that would say, okay, this was actually conducted by China or by a Chinese government official. That is an additional layer that you would have to prove that this was actually somehow conducted either through the government or controlled by the government.
You would probably need a cyber operation to really attribute it clearly, no?
That is true. These are also counterintelligence operations that are being actually conducted, but states are not really, I would say, states are not very open about what they're doing.
Would it even be admissible? If you gather evidence in a way that is not quite legal either?
That, again, is the subject of a lot of debate, I would say. Even into the question whether offensive cyber operations are allowed under international law. So if you can, for example, infiltrate a system in China, let's say, and you find out vulnerabilities, you put in a backdoor, and then you establish an access to that system, even before you actually were attacked yourself. These are so-called offensive cyber operations, or I think you can call them like that. And these heavily debated whether this is actually allowed. But the argument is that you have to do it before you are being attacked in order to actually being able to counter this operation. So there's the question, actually, how does international law regulate this conduct? I think you can say that this could be a violation of international law, but maybe it's already below that threshold.
Actually, I have a final question that we have not covered yet, which is the question of cyber sanctions. So obviously, if there's a violation of international law, normally you can obviously condemn it, and you can also on a UN level or a EU level or even on a nation state level impose sanctions on the perpetrator. Do sanctions even work in the cyber sphere? Let's not go into the debate where the sanctions work at all, but just what is different with cyber sanctions from normal economic targeted sanctions against, I don't know, Russian oligarchs or something like that?
So the EU has tried to respond to malicious cyber operations with imposing restrictive measures, or its so-called EU cyber sanctions regime. This is one of the examples. The United States also has sanctions against Russia, for example, for cyber operations. But in the EU, we have a very comprehensive cyber sanctions regime. I think it's definitely a signaling method to show that you condemn the activity and they do not align with your principles. But it is definitely doubtful whether these actually work. If you think about targeted sanctions, the way these work at the EU cyber sanctions regime is that you have asset freezes and you have travel restrictions on certain people that are being listed in the annex of that sanctions regime. So this means that, for example, you have a Russian hacker that is part of the GRU, so the Russian intelligence agency, and you have this Russian hacker. He's, I would say, 21 years old. He's male. He's never traveled to Europe, and he doesn't have any assets, of course. He doesn't have a bank account or anything in the European Union. So imposing asset freezes on this guy and travel restrictions of a person that never plans to visit the European Union, you can doubt whether these are actually effective. I think they're effective in the way that they signal discontent and that the EU doesn't want to just sit by and watch how it is being attacked. But as to effectiveness, we could argue this is doubtful. Or maybe just as a comparison, as you said, with other regimes, where you, for example, have Russian oligarchs who are being listed. These are people that have an interest of traveling to the European Union. I mean, there always the argument is being made that, a very rich person has a wife and the wife wants to go to Europe and go shopping. That's the very sexist example that is always being used, or who wants to send the kids to school in Europe. That is, of course, not made possible if you have sanctions imposed against that person, if you have travel restrictions on them. That you could argue that this is perhaps a little bit more effective than on these typical examples of cyber sanctions.
Thanks, Isabella. I think, unfortunately, we're running out of time, but we have a lot more to discuss. So we're going to have a second part of this podcast. For now, we have to wrap it up. So thank you very much for the first part. And then we'll talk to you straight away after this in the second episode. Thank you.
This was the first half of our conversation with Isabella Brunner, because she is such an interesting expert and because there is so much more we wanted to ask her after this. We decided to split up the conversation into 2 episodes. So you will get the second part of our conversation with her a little bit later. And now we have an announcement for you, Jeroen.
Yeah, we still have something coming up as well before we broadcast the second episode. And that's that we have the Nürnberg security talks coming up. This is a series which is organized by our colleagues from the FNF office in Bavaria. And that's a series of talks taking place on different security related topics from the 18th of June to the 10th of July. Some really exciting speakers. We'll put the link in the show notes so you can find it there, and it would be great to see many of the listeners there.